One thing that we're going to need to work out if you're going to be on a 50-50 schedule is who's going to get to claim those tax credits. Remember that taxes are a federal level issue, right? So, and the federal government is not beholden to a state level divorce or custody decree as to what's going to happen with the taxes, right? So, usually we work some kind of agreement, and depending on what the parties agree, that can look like several different things. It could be that we alternate. So one year mom gets credit, next year dad gets the credit. Or if there's more than one kid, mom is going to claim the oldest each year and dad's going to claim the youngest until the oldest ages out, and then they're going to flip-flop and rotate years. So there's lots of different things that we can do on that agreement, but there will need to be some kind of agreement to address it. In Texas, attorney's fees can be awarded in a case. It's usually pretty rare, though. We always just kind of, as a matter of practice, plead for attorney's fees unless we're doing an agreed case. And that's standard. If you read pretty much anybody's pleadings in a divorce case or in a custody case, we're going to ask the court to award us attorney's fees. It's very rare that the court actually awards attorney's fees. Usually what happens is both parties pay their own. Now, there's a couple of caveats. So if it's a divorce and we have, a high income earning spouse and one that doesn't have as many resources, then the court could award the lower income earning spouse some attorney's fees out of the community estate. So, it was still that party's community property interest paying for the fees. They just are ordered through the court so that we can more or less equalize the funds available for an attorney in a divorce case. The other way that fees get awarded during a case is more punitive, right? So if there is a party that is not doing what they're supposed to, they're not following the court's order, we have to file an enforcement or a motion to compel, like on a discovery request. Attorney's fees can follow that. So, but just in a general course of a divorce, assuming that both parties are kind of doing what they're supposed to under the orders of the court is very unlikely to award attorney's fees. When grandparents have custody, the court is usually going to order both biological parents to pay support. Okay, so only parents have an obligation of support. Non-parent possessory conservators cannot be ordered by the court to pay child support. So if grandparents or even an aunt or uncle have the kids for some reason because mom and dad aren't capable of caring for the kids, then the court is most likely going to order not only dad, not only mom, but both parents to pay support for the child. How do we do child support when there's a 50-50 or joint custody arrangement? So in Texas, because there's not a 50-50 presumption in the Texas Family Code, there's no direct child support guidelines for a 50-50 possession schedule. What we normally do in that situation is we say, okay, so if dad were the one to pay child support based on dad's income, what would that calculation be under the code? And so let's say dad's child support obligation under the code would be $1,500 a month for 2 kids. And then we say, okay, if mom was the one paying support based on her income, how much child support would she pay? And so let's say that number is $1,000 a month for easy math. So we take dad's child support number and mom's child support number, and we subtract them. And whatever the difference is the offset. And so in this case, it would be $500. And since dad pays more, or dad makes more, then dad would be the one to pay that offset of $500 a month. If you have questions about child support or custody, we would love to talk to you. Give us a call.